friends, welcome to our channel, The Pain and Pride of Modern Homeowner Spirit. We are thrilled to have you join us on this journey of self-empowerment. Here, we delve into the art of cultivating inner strength and your permanent resolve, critical qualities for navigating the challenges of modern life. Please listen to Joshua Valentine and Joanne Ashdeen, helping to guide you in fostering a deeper and more intimate connection with your home. So, let's embark on this transformative journey together, unlocking the potential within ourselves and our homes. I welcome you to the modern homeowner community.
Welcome to the deep dive. Today, we're jumping right into something, well, a lot of homeowners might find familiar, especially if you're in a condo or, a planned community. It's all about how decisions get made about, maintaining the shared spaces. Our focus is a really interesting case. Lamden v. Jolla Shores Clubdominium Homeowners Association.
Exactly. And we're going to unpack this key decision from the California Supreme Court. It all kicked off with something, pretty mundane actually, dealing with termites in a condo complex.
Right, termites. Sounds simple enough.
Yeah, but believe me, this case became a much bigger deal. It really dug into how much power a homeowner association, an HOA, actually has and what rights you have as an individual homeowner living there.
So, paint the picture. Your HOA decides, let's say, they're just going to spot treat for termites. Limited approach. But you think, no, we need full fumigation. That's the only way to really fix this and, protect my investment.
That's pretty much what happened to Gertrude Lamden at Jolla Shores. And yeah, her disagreement, it went all the way up to the California Supreme Court. Quite the journey for a termite problem.
Wow. So for this deep dive, we've got the actual text.
Yeah, we're looking at excerpts straight from the California Supreme Court's opinion. The real deal.
Okay.
And our mission for you listening today is pretty clear. We want you to understand the legal standard, the sort of measuring stick that courts use when they look at decisions your HOA board makes, especially when it's about maintaining and repairing those common areas.
The stuff everyone shares.
Exactly. And this Lamden case, it really set a major precedent. So it's definitely worth understanding if you live in one of these communities or, frankly, if you're even thinking about buying into one.
Okay, let's get into the heart of it then. Gertrude Lamden. She didn't just complain, she actually sued the Jolla Shores Clubdominium Homeowners Association.
She did. Her main argument was that the board's choice, just spot treating for termites instead of the full fumigation, was actually hurting the value of her own condo.
Okay, so it was about property value for her.
Primarily, yeah. Initially, she was looking for a few different things in court. She wanted damages, money for the lost value. She wanted an injunction, that's a court order, forcing the association to fumigate.
Right.
And she also wanted something called declaratory relief, which is basically asking the court to just spell out everyone's rights and duties in this situation.
Like who's responsible for what?
Exactly. But by the time the case got all the way up to the Supreme Court, she'd actually narrowed her focus. She was really just going for the injunction and that declaratory relief.
So less about the money at that point.
Seems like it became more about the principle.
Yeah.
What should the association be required to do?
Okay, so why did the HOA dig in their heels on spot treatment? I mean, nobody wants termites, right?
No, definitely not. It wasn't like they were pro-termite. The board actually had quite a few reasons for their decision, and it's important to see their perspective, too.
Fair enough. What were they?
Well, first off, cost. Fumigation is significantly more expensive than spot treatment. That was a big one.
Always a factor.
Always.
Yeah.
Then you've got the sheer logistics of it. Trying to get everyone out of their homes temporarily, that's a massive headache.
Oh, yeah. Coordinating that sounds like a nightmare.
Total nightmare. And they also had real concerns about, potential health and safety issues. The chemicals used in fumigation, worries about residue.
Right. People worry about that stuff.
Understandably. Plus, the board also mentioned they already had plans for walkway renovations coming up.
Okay.
And those renovations were actually going to replace some of the wood that had termite damage anyway. So they figured some of it would get fixed through that project.
Ah, okay. So there was some overlap.
A bit, yeah. And they also considered other things too, like the hassle and cost for residents moving pets.
Little things add up.
They do. And the risk of the fumigation company may be damaging personal property inside units, or owners losing rental income if they lease their places out. And, kind of depressingly, they even noted that termites could potentially come back even after a full fumigation. It wasn't necessarily a guaranteed permanent fix.
It sounds like they weighed a lot of different factors.
They did. They basically decided, let's try the less drastic, less expensive option, first the spot treatment, and see if that manages the problem adequately.
Okay. So the case goes to trial. What did that first judge decide?
Well, the trial court actually sided with the HOA.
They did. Okay.
Yeah. They acknowledged, look, there's definitely a termite problem in Lamden's unit and in the building. That wasn't really up for debate. But, and this was key, they found there wasn't any imminent danger to the building structure.
So, not about to collapse tomorrow.
Exactly. Annoying, damaging, yes. An immediate structural threat, no. At least that's what the court found.
Got it.
And based on that finding, the trial court said the board had a rational basis for its decision. They used this legal standard called the business judgment test, basically saying the HOA's choice was reasonable, even if maybe not the only reasonable choice.
So, round one to the HOA.
Pretty much. The initial ruling was in their favor.
But, as often happens, that wasn't the end of the story. The Court of Appeal saw things differently.
That's right. The next court up, the Court of Appeal, they disagreed with the trial court's approach. They took a different view.
How so?
They argued that the HOA had, a positive duty, an objective duty to use reasonable care in maintaining the common areas.
Okay, reasonable care. That sounds different from just rational basis.
It is. It's generally seen as a slightly higher standard. The Court of Appeal felt the question shouldn't just be, was the board's decision rational, but rather, did the board act with reasonable care? And they thought applying that standard might lead to a different result for Lamden.
So they basically said the trial court used the wrong measuring stick.
Essentially, yes. And they overturned the trial court's decision because of it.
Which then sets the stage for the California Supreme Court.
This is where it gets, as you said, really interesting. Why did the state's highest court decide to weigh in? Well, precisely because you had this conflict, right? Yeah. The trial court said rational basis. The Court of Appeal said reasonable care. The Supreme Court needed to step in and clarify what is the correct legal standard for courts to use when reviewing these kinds of HOA board decisions. They took the case specifically to resolve that uncertainty.
Okay, makes sense. Now, you mentioned earlier this idea of the business judgment rule. Was that part of the HOA's argument? Were they saying, treat us like a business board?
Yes, absolutely. That was a key part of the HOA's defense strategy. They argued that the business judgment rule, which normally applies to decisions made by the boards of directors of corporations.
Right, like big companies.
Exactly. Should also apply to the decisions made by HOA boards.
Okay, for listeners maybe not up on corporate law, what's the gist of that rule?
Sure. The business judgment rule, in a nutshell, it's a principle of judicial deference. Courts basically say, look, as long as a corporate board acted in good faith, was reasonably informed, acted within its authority, and rationally believed the decision was in the company's best interest, we're not going to second-guess their business decisions.
Even if the decision turns out badly later.
Even then, generally speaking. The idea is that running a business involves risk, and judges aren't usually business experts. They shouldn't be Monday morning quarterbacking every strategic choice.
So the HOA was basically saying, hey, we made a calculated decision about termites based on costs and logistics and everything. Unless you can show we acted in bad faith or totally unreasonably, the court should stay out of it.
That's the core of it, yeah. But interestingly, the California Supreme Court ultimately decided that the traditional business judgment rule, as it applies to corporations, wasn't quite the right fit here.
Oh, why not? What was missing?
Well, they pointed out a couple of things. First, in this specific case, Gertrude Lamden was suing the HOA itself, the association as an entity. She wasn't suing the individual board members personally.
Ah, okay.
And the traditional business judgment rule often provides a layer of protection for those individual directors against personal liability.
Yeah.
Since they weren't defendants here, that aspect wasn't directly relevant.
Got it. So the personal shield wasn't the issue. What else?
The other main reason was that this particular HOA, Jolla Shores, was an unincorporated association.
Okay. Not formally set up as a corporation.
Right. And the court noted that the statutes and the common law history of the business judgment rule were really geared towards corporations. While you could argue it should apply more broadly, the specific legal protections written into, say, the California Corporations Code for directors didn't perfectly map onto the situation of an unincorporated HOA board making general decisions.
So technically, it wasn't a direct match.
Exactly. Because of those factors, the court felt simply importing the standard corporate business judgment rule wasn't the right move.
But they didn't just say, oh, well, figure it out, right? They still needed to provide some standard.
Absolutely. And this is really the crucial part of the Lamden ruling. The Supreme Court acknowledged the need for clarity. So while they didn't just copy-paste the corporate rule, they established a new standard, a rule of judicial deference specifically crafted for community association, board decisions about ordinary maintenance and repairs.
Okay, so a tailored version. What does this new standard actually require? When should courts defer to an HOA board's decision? What are the criteria?
Right, this is the practical takeaway. The court laid out several conditions. For this deference to apply, first, the board has to be duly constituted, meaning it's properly formed and acting according to the rules.
Legitimately elected and all that?
Right. Second, the decision must be made after a reasonable investigation. They can't just wing it. They need to actually look into the matter, do their homework.
Makes sense. Don't ignore the termites without checking things out first.
Exactly. Third, the decision must be made in good faith. No fraud, no self-dealing, no, malicious intent.
Basic honesty.
Pretty much. Fourth, the decision has to be made with regard for the best interest of the community association and its members, the community as a whole.
Not just one person's agenda.
Correct. Fifth, the board needs to be exercising discretion within the scope of its authority. They have to be acting within the powers given to them by law and by the community's own governing documents, the CC&Rs, bylaws, etc.
Can't make rules about stuff they have no power over.
Right. And finally, the decision has to be specifically about selecting among means for discharging an obligation to maintain and repair the common areas. This rule is really focused on those kinds of upkeep choices.
Okay, so if a board meets all those conditions, they're legit, they did their homework, acted honestly for the community, stayed within their power, and it was about a maintenance choice, then the court should generally back off.
That's the essence of the Lamden standard. The court is saying, look, if the board followed a reasonable process and acted in good faith within its authority on these maintenance issues, judges shouldn't substitute their own judgment for the board's.
For you listening, that's the key. HOA boards get significant leeway on maintenance if they follow these steps reasonably.
It recognizes they're often better placed to make those calls.
Now, you mentioned this wasn't the first time the California Supreme Court tackled HOA issues. How does Lamden fit with other big cases? Wasn't there one about pets? Narstedt.
Yeah, good question to see the context. The court did talk about that. They mentioned Narstedt v. Lakeside Village Condominium Assen. That case was about enforcing CC&Rs, specifically a no pets rule. And in Narstedt, the court also emphasized respecting the community's governing documents, saying those rules are generally enforceable unless they're wholly unreasonable or violate public policy. Sure. So Lamden, in a way, builds on that theme of giving deference to how these communities choose to govern themselves, at least regarding maintenance decisions made by the board.
Okay, so it aligns with that deference idea. What about that other case, Francis TV Village Green Owners Association? That sounded more serious. Someone was attacked.
Yes, Francis T. is a really important case to contrast with Lamden. In Francis T., a homeowner was assaulted in her condo, and she sued the HOA, arguing they failed to provide adequate lighting in the common areas, making it unsafe.
Okay, so a personal safety issue.
Exactly.
Yeah.
And in that case, the court said an HOA could be held to a standard similar to a landlord's duty of care when it comes to keeping common areas safe from foreseeable harm.
Oh.
The big difference the Lamden court highlighted is that Lamden was about an economic decision regarding property maintenance, termites, and property value. It wasn't about preventing direct physical injury to a resident.
So different types of harm, different standards.
Precisely. The heightened duty of care from Francis T., focused on safety, didn't really apply to the termite situation in Lamden, which is more about how best to manage and pay for repairs.
Okay, that clarifies the distinction. Lamden is really zeroed in on those practical financial upkeep decisions. So why did the Supreme Court think this deference was so important? What was the rationale behind giving boards this leeway?
They laid out several pretty compelling reasons. First, just practical expertise. The court basically said, homeowners and their elected directors are usually in a better position than judges to make these detailed, often complex, economic decisions about maintenance.
They know the building, the budget.
Exactly. They're closer to the situation. Second, the court wanted to discourage a flood of lawsuits over everyday board decisions.
Right. Avoid clogging the courts.
Yeah, they worried that if every single maintenance choice could easily end up in court, it would create instability and make it really hard for HOAs to function effectively. This deference promotes predictability.
Lets the board, do its job.
Right. Third, they felt this approach might actually encourage more owners to volunteer for the board. If directors feel they have the breathing room to make reasonable decisions without constant fear of being sued personally or having every choice second-guessed,
they might be more willing to step up.
That was the hope. And finally, conserving judicial resources. Courts just don't have the time or, frankly, the expertise to micromanage every HOA repair decision.
Okay, that all seems logical, but this deference, it isn't a blank check, is it? It sounds like there are still limits. HOAs can't just do anything.
Oh, absolutely not. The court was very clear. This deference isn't absolute. It hinges on the board meeting those criteria we discussed.
Reasonable investigation, good faith, etc.
Right. If a homeowner can show the board didn't do those things, maybe they acted without any real investigation, or clearly acted in bad faith, or made a decision way outside their authority, then the court can step in. The deference disappears if the board doesn't hold up its end of the bargain.
So there's still accountability if they really mess up. Was there an example mentioned where an HOA did get overturned?
Yeah, the court actually brought up another case, Fountain Valley Chateau Blanc, homeowners, a Department of Veterans Affairs. It's a bit of a mouthful.
Yeah.
In that one, the HOA went after an elderly homeowner, basically claiming his stuff was a fire hazard and demanding he clear it out.
Yeah.
But the evidence suggested they didn't really believe it was a fire hazard. It seemed more like harassment.
Oh, wow.
Yeah, and the jury found the association had acted unreasonably. The Court of Appeal upheld that, basically saying the HOA's actions weren't based on good faith or reasonable investigation. So that case serves as a reminder. When HOAs clearly act unreasonably or outside the bounds of good faith, courts won't just defer.
Good to know there's that backstop. So let's bring this home for everyone listening. Why should someone who just wants to be informed care about the legal nitty-gritty of this termite case from years ago?
Well, look, if you live in a condo, a planned development, any kind of community with an HOA,
Which is a lot of people.
or if you're even thinking about buying into one, or heck, even if you're just interested in how communities are governed, understanding this rule of judicial deference from Lamden is really crucial.
Why specifically?
Because it defines the balance of power, in many ways, between the association board and you, the individual homeowner, when it comes to decisions about maintaining the place you live. It tells you the board has significant authority, yes, but that authority isn't unlimited. It comes with responsibilities to investigate, act fairly, stay within bounds.
So it helps you understand the rules of the game, essentially.
Exactly. It helps you know what to expect from your board, and it gives you a framework for understanding if maybe they have overstepped or acted unreasonably and what the potential recourse might be. It's about being an informed resident.
Okay, so summing up our deep dive today, the big takeaway from Lamden v. Jolla Shores.
The main point is this. The Lamden case established this principle in California judicial deference. Courts will generally respect an HOA board's decisions on ordinary maintenance, like fixing termite issues, if the board acts properly. Meaning the board is properly set up, they do reasonable homework, they act in good faith, they consider the community's best interest, and they stay within their legal powers. If they check those boxes for routine upkeep decisions, courts tend to step back. It's about balancing efficient community governance with protecting homeowners from truly arbitrary or bad faith actions.
So the bottom line for listeners, your HOA board has a fair bit of leeway on maintenance stuff, as long as they aren't acting, completely out of line or unfairly. The court's not going to nitpick every repair choice.
That's a good way to put it.
All right, and as we wrap up, maybe a final thought for you, the listener, to chew on. Considering this Lamden ruling and the deference it grants boards, how might that actually impact homeowner involvement? Does knowing the board has this leeway make you feel more inclined to get involved to ensure decisions are good, or maybe less so, feeling like it's harder to challenge things?
Interesting question.
And does this standard strike the right balance, especially when you're talking about decisions that could cost a lot of money or really affect your quality of life? What does this raise for you about how these shared communities should ideally be run and how individual voices can or should be effectively heard within that structure? Maybe even, dig out your own community's governing documents sometime, see how they handle maintenance and decision making. It's definitely worth pondering how these Lamden principles might apply in different real-world scenarios you could face.
I want to take a moment to connect with you. If you are finding value in this content and want to empower your intimate connection with your home, please take a second to like this video. Your support helps me create more free content like this. Also, I'd love to hear your thoughts and experiences. Drop a comment below with any questions or insights you have. Let's create a community where we can learn and grow together. And if you haven't already, make sure to subscribe to the channel. Our dream is to reach 1,000 subscribers, and with your support, we can reach this milestone together. By subscribing, you'll stay updated on all our latest content, helping you cultivate inner strength and deeper connections in every aspect of your home ownership. Thank you for being part of this journey.